Open this final morning of the final meeting of the Convention on the Constitution. I think everybody enjoyed last night. I think it was a truly memorable and again our renewed thanks to everybody who had a hand in it, obviously all of the hotel staff, and I think also the level of detail and attention to the programme that you had last night was really a tribute to the very hard work and hard thinking of the Secretariat. So sometimes, of course, the best laid plans don't completely are not completely realised, and one of the ones that I missed last night in my list of thanks to people was I omitted to thank the staff of the Taoiseach's Protocol Department, particularly Pat and Mary, and all the staff. So, just the programme this morning, we are going to start by hopefully agreeing the ballot paper. We've been working on, we've revised it by comparison to yesterday, taking account of comments that were made in the course of the discussion yesterday and some other comments, and hopefully it's close enough to what you would wish to vote on, but that's obviously open to discussion. We will, the way we're going to do this is that David is going to recall for us, he's going to, with a series of slides, summarise the content of the discussion yesterday. You already saw a version of this in the early afternoon yesterday, but this is again a revised version of those slides, which attempts to capture the very vigorous debate we had in the course of yesterday afternoon. So that's, I think, perhaps a very good starting point to remind us of what happened yesterday. And then, you know, obviously the ballot paper is an attempt to reflect the discussion yesterday and the sort of emerging themes. And Leah is going to take us through the ballot paper. So that's the initial part of today's programme. So could I invite David to take us through the slides.
Okay, good morning, everyone. These slides are based on the discussion you had yesterday afternoon, directly after the debate with the advocacy groups. So it's the material that you were discussing yesterday afternoon. And as ever, it's an attempt to try and put down the main points, but apologies for anything that's been missed. This was done at some speed. So there's 4 slides this time. First of all, arguments for leaving things as they are. It's too complex to put something like this into the Constitution. It's hard to define this. That clearly was a point that came up quite a few times yesterday. These rights are already sufficiently protected. Or another version of that point, we should concentrate on fixing existing things that are already protected rather than adding to the list. This can be dealt with via legislation. It doesn't need constitutional reform, was a point that came up. There's the dangers of unintended consequences. I think that was a point that came up in the debate quite a bit. And who would pay the bill? It's all very well doing it, but who would pay for it in the end? And then arguments for enforceable economic, social and cultural rights. So the opposite set of arguments, as you will. It forces the government to prioritise the citizens' wishes. The current constitution is too weak regarding economic, social and cultural rights. People have a right to a framework for good government. There is an appetite for change to include these rights. And a version of that, times have changed since 1937. It is a fair time, of course. We are in a more diverse, multicultural society in particular. Not to do this would be a big missed opportunity for the Convention. I remember hearing that in the debate yesterday. Following the legislative route would leave it to the whim of governments of the day. So clearly it'd be better to put it into the Constitution instead, is the point. And a point that did come up in the discussion as well yesterday, it might actually save money in the long term. So it's not just that who's paying the bill, but there might be a lesser bill is the point that's been made there. The third of the 4 slides, the third slide is some possible approaches. This is a version of what came up from the morning's discussion as well, of course. Some possible approaches: make changes but leave the details for the legislators, with due regard to the resources available. So in other words, some suggestions of changes, but let the legislators, let the Parliament deal with it all, deal with the detail. Amend Article 45 to allow scope for rights to be introduced progressively, depending on resources, more graduated, in other words. And then particular support. This is sort of coming together, bringing together a couple of points from different tables. The sorts of issues for specific rights that might be mentioned if you were to go down this route: housing, health, welfare, and education. These ones came up quite a bit. And the final slide is arguments for lighter touch reforms. Reforms that might not necessarily include constitutional change. So that lighter touch reform would be to say that the court enforcement should only happen in exceptional circumstances, as opposed to that the courts would have total say over it. I can't pronounce that strange word we all were told about yesterday. Update Article 45, including provisions on employment, health, housing, social welfare, minimum income. So some other issues that came up. All cases to go through some sort of independent ombudsman role before there's a recourse to courts, to try and stop the courts from getting swamped, is the suggestion here. This came up from a few tables. I should have put this in one in red. Proposed that a task force or review group, the different terms were used by different tables, be established to work out the details. This is the point about whether it could be done by the convention, the actual details, or whether the convention gives a signal and gives it to some other entity to go into the details. Propose areas for specific legislative reform, for example, in following the UN Convention's proposals. And then finally, the final 2 points, that a lighter touch reform might be to try and make access to the court system quicker, faster, to stop the long, long delays that citizens have to go through. And another version of that sort of thing, to extend free legal aid to facilitate citizens taking cases to the courts. So they're the 4 slides that sort of summarise, I think, quite usefully what you were all discussing yesterday afternoon, and which would seem to feed in quite well, I think, to the discussion about the ballot paper. So I'll hand over to Leah.
Thank you, David. Okay, you all have a copy of the ballot paper in front of you there. I think just before I speak to that, I think I'll just recap again on sort of what economic and social and cultural rights are already protected by the Constitution, or at least are arguably protected by it. And I'm just using as my template here Liam Thornton's initial listing of the rights. You know, he mentions the right to work. That is protected already as an implied right in the Constitution. The right to participate in trade unions, that is already protected by Article 40.6.1, freedom of association and so on. The right to strike is probably protected. The right to private property, as we know in 2 separate articles of the Constitution, is protected. So the economic rights generally that we know of are protected in the Constitution already. Social rights then, again, it's a slightly more grey area here, but I mean, you do have the right to bodily integrity in the Constitution, which in turn means the right to health. So you could say that's the right to adequate food, water, clothing and shelter. Again, arguments could be made there, but there are a lot of implied rights in the Constitution, and physical and mental health and so on. The right to education is specifically protected in the Constitution, Article 42, and there is a clear duty on the state in that regard. The state shall give free primary education. Then there's the rights to social protection of the family. That's an arguable one. I mean, the Constitution doesn't mention social protection, but it does talk about protecting the family in Article 42.4. And then we get into the cultural rights. Obviously, in our Constitution, we have a specific provision on the Irish language in Article 8 of the Constitution. And then we have protection for religious freedom as well. So you could say that protects the right of groups to practice their own faith and so on. So, you know, it's not crystal clear or anything in the Constitution, but I suppose you could say that many of these rights are arguably already protected, and some of them are expressly so. So given that background then, that's where we're coming from with this ballot paper. We're saying, are you happy with that situation, or do you want, in question 1 there, do you want the protection of economic, social and cultural rights to be strengthened? Okay. Question 2 then is, in the event the Convention votes in favour of reform, does the Convention wish to make recommendations now, or does it want to refer this issue elsewhere for further consideration of the implications? And that suggestion arises from some discussions yesterday where at least one speaker claimed that this was a complex issue and the implications needed to be fully teased out. The third question then is, if the Convention wishes to make recommendations on the issue now, which options are best? And we've given you 3 options there that we're just trying to broadly reflect the discussion at the tables, and you can actually rank these options 1, 2, 3. You don't have to just pick one. But the idea there is that option 1 is a very minimal protection, whereas option 3 is a much stronger protection. And option 1 would really just involve updating the language of Article 45 of the Constitution, but keeping the notion of principles of social policy which are not cognizable by the courts. So we'd be keeping a lot of these economic and social issues arguably in the realm of principles rather than rights. Option 2 then, it's just wording that we came up with to try to reflect, as I said, what was said at the tables, is this notion that the state shall endeavour to progressively realise these rights. Now that's a very weak version of the right, because if you tried to enforce that in the courts, you would really probably only win your case if you showed that the state had completely failed to attempt to protect a particular right or set of rights. And option 3 then is stronger language again, kind of borrowed from the international convention, if you like, but not intending to actually incorporate the whole convention into the Constitution. We're just using the wording there because it's a nice turn of phrase, this notion that the state shall progressively realise these rights, subject to maximum available resources, and that this would be justiciable. Okay. I should just mention, as a footnote to that there are some rights, as I said, like, for example, the right to primary education and the rights in relation to the Irish language and so on, that are already completely justiciable and are clearly stated as a duty on the state that it shall protect them. So we wouldn't be interfering with trying to dilute that duty here. We're talking about what additional protections we would want to add. The fourth question then gives you an option to sort of flag particular rights that you might want to see expressly mentioned in the Constitution. And it's not meant to be an exhaustive list or anything, but again, it's just reflecting several of the rights which people expressed concerns about yesterday, that they were either not protected in the Constitution or weren't sufficiently protected in the Constitution. Okay, questions, please.
Okay, questions or comments? David. Could we have the mic up here, please, Lorraine? Yeah, thanks.
Yeah, first of all, just to commend the Secretariat for putting the ballot paper together. It's obviously very difficult given the different opinions that were heard yesterday, but just a number of observations and questions just for clarification purposes, and just a number of concerns I would have about some of the terminology that's been used. I don't have a difficulty with the first and second ones, which I think obviously are very straightforward, but the third option, which it looks at the 3 options, and it's good that there's a ranked preference, but I think in all 3 we should restate that we're talking about economic, social and cultural rights. It just says these rights are, so we're clear about exactly what we're being asked to support. And Leah made the point that the second option, and just to get a legal opinion on this, to me would have 3 qualifications. It would have the qualification of shall endeavour, then progressively realise, and also subject to maximum available resources. But the shall endeavour is so weak to be almost non-existent. You know, it would be very difficult to enforce in a court. The language, I think, is very weak. Now, I see option 3 obviously is much stronger, but just so we get clarification on what would be the legal implications of the difference between the 2 in terms of those being enforceable in the courts. And the fourth one is in relation to just a general point about the fourth one, where it asks us, you know, what rights would we want looked at. It doesn't have any reference to our international obligations, such as the International Covenant on Economic, Social and Cultural Rights. Like, surely we should be aspiring to at least get to the international rights that we've already signed up to, and there's that floor, but there's no reference to that, which I think might have been helpful maybe in question 4 as well, if that could be looked at. And the last one is in where it says emergency healthcare. Emergency healthcare, again, is very narrow. I mean, essential healthcare might have been a better turn of phrase. That emergency healthcare, in my view, would be extremely narrow. And you know, I think essential healthcare would have been a better phrase. Thank you.
Yeah, would
Yeah.
you take that, Leah?
I'll respond to those, Chairman. Thank you, David. Your points are excellent, very helpful. Thank you. Your first point, I agree that we should put in the reference to economic, social and cultural rights there instead of saying these rights in question 3. Sorry, your second point about option 2 being very weak, yeah, it is extremely weak. I mean, it's barely more than having principles which are not cognizable by the courts at all. It's just this idea that conceivably in an extreme case where there was utter failure by the state, you might be able to take a case against the state. So it is very weak. Option 3 is the stronger one then. I mean, we had in the initial ballot paper an option 4, which is basically make all these rights enforceable, but I don't think there was much support for kind of going down that route without some kind of qualifications. That's not what we understood to be the view anyway. So yes, if you're voting for option 2, it's extremely weak. It's just moving from the notion of principles to rights and moving to at least the possibility of judicial involvement in some extreme circumstances. I'll just deal with your latter 2 points in reverse order. Essential healthcare is an interesting word. I think it's a good suggestion. The reason we put in emergency there, as you know, is we initially had healthcare in the draft, and somebody rightly suggested that might be too broad. Emergency healthcare is possibly too narrow, and so therefore essential healthcare is an interesting term if you're interested in putting that on the paper. And the final point then, the notion of referring to the rights in the covenant. I mean, that could be done here in the list. You know, we could simply say those rights listed in the International Covenant on Economic and Social Rights. You know, that could be done here. Now, that would be kind of awkward to work out if there was to be a constitutional amendment on this, because you would then have to ask yourself whether you would just rewrite all of the economic and social and cultural provisions in the Constitution, which involves many articles of the Constitution, and substitute these, or whether you'd be adding these on. And there'd be a lot of overlap there. So it would be messy, but I mean, we can put that on the ballot paper if you want to flag that option. It's just there would be a lot of thought to be done down the line by anybody who was trying to implement or trying to form a referendum proposal on the basis of this. Okay, thanks again.
I think, Leah, there was another suggestion made after we have finished this version of the ballot paper that the phrase social welfare should be changed to social security.
That's right, Chairman. Thank you. Yeah.
So are there other comments? Yeah.
Terry, yesterday evening, Ivana...
Sorry, could we speak into the mic?
Sorry.
Yeah.
Yesterday evening, I suggested that perhaps there should be 2 vacant places on question 4 that people could add perhaps additional items that they think is important, perhaps maybe in education to go to secondary or tertiary levels, or other comments that they may have. And again, I would second David's opinion that the covenant should be, the option of putting in the covenant should be perhaps added as well. Thank you.
Thanks, Terry. We'll deal with your first point in a moment. Well, we'll deal with both your points, sorry. Susan first, and then Jerry Buttimer.
Thank you, Chair. Just also to support the idea of possibly having a space for other options, because I think somebody yesterday also mentioned the cultural part, that really we hadn't quite kind of spent as much time perhaps on that area. My main query relates to option 1 and the updating of Article 45, and I'm just not entirely clear what the word update means in that context. Yeah, I think that's probably clear enough.
Okay. Jerry, please.
Good morning, Chairman. Jerry Whitmore. Just in terms of the issue in terms of health, I wonder could we maybe adopt the South African model where they say no one may be refused emergency medical treatment? That might work, maybe.
Okay. We'll take all of these comments and attempt to reach a consensus view. There's a couple of comments there. Is it Martina who wants to speak? Or oh, sorry. Yeah. Sorry, Katrina first, and then Martina, and then John.
Okay, Gurmagad Kahir, look. Just the option 3 on the second box, and I mean, I think it's, we've had some useful clarification in relation to, the option 2 and option 3 in terms of the weakness or potential weakness of option 2. But just a clarification, there's some rights that are immediately realisable now, or the duties on the state to immediately carry them out now. If we substitute option 3, is there wording we could put in there to make sure that we don't lessen rights rather than...
Exactly.
And then the other point, I'd be very worried about us leaving emergency healthcare or any reference to emergency. I think essential or just healthcare, because otherwise you have courts deciding what's an emergency and what isn't an emergency, and I don't think that's appropriate at all.
Okay, thank you. Martina?
Martina O'Connell, thank you. I think my question has been addressed now by speakers here this morning. Yes, in regards to emergency, I think we have emergency health cover in this country. Anybody that comes into hospital will be treated in an appropriate manner if their condition is life-threatening. So perhaps we could take the advice of maybe David and use essential health cover, but I think putting an emergency into it will make it very, very complicated and difficult to define. So perhaps use a different word like essential.
Okay, fine. Thanks very much for that comment. Did I see John? Yeah, John, please. Yeah.
John Connolly, Dundrum. I suppose, Mr. Chairman, the biggest disappointment I've had is referable to the economic relationships. If we haven't got money, we can do very little to uphold rights. And we've just gone through a major, the Western world in one sense, and Ireland in a particular sense, in terms of the way we conduct our financial institutions, particularly referable to regulatory offices of the central bank and of the regulator himself and of things like that. And I think that the public at large are going to be disappointed that perhaps this element of our governance or our recommendations for governance hasn't been addressed with perhaps the need that we require or what's required of us. I feel that in regulatory control, we've made no suggestions for strengthening the arm of either the judiciary or of the executive to have ad hoc decisions that led us into a 62 billion chasm taken overnight was not adding anything to our rights. We got nothing out of it as a right. And I think that without this point being addressed, we're missing a golden opportunity to say, please, never again allowing this kind of happening to arrive at our doorstep. Thank you.
Thank you. I would like to go back to Leah now at this stage to respond to the various questions that came up.
Okay, thank you, Chairman. I'll do my best to remember the questions, but please intervene if I forget anything. Okay. The first point there from the gentleman over here was in relation to having an extra option in the last question there where you could fill in other suggestions yourselves. Now, David might want to say a word about this, but I know that would be very difficult to tally or to count up as a ballot paper. However, it might be possible, this is just a suggestion from me, to put in something at the end of the ballot paper where you could write in extra suggestions, but they wouldn't be counted as a ballot. They would instead be reflected in the narrative of the report. So, for example, we could reflect back in a report that these suggestions arose, but it would be extremely difficult to try to count up these suggestions, which might be all worded differently. So is that a reasonable compromise there?
That's a reasonable compromise, I think, yeah.
The second point then from Susan was in relation to updating Article 45. Admittedly, that's a fairly broad suggestion in itself, but I suppose the idea there was that we might change the what but not the how. In other words, that Article 45 would still contain general principles which would not be justiciable, but on the other hand, we would change the language to reflect various concerns and so on. I mean, we're not going to go into detail what they are, but as I mentioned before, the article mentions, the ages, the widow and the orphan and that type of thing, and we might start improving all that language to talk about, people with disabilities and the principles of justice to inform our society and so on. So we're not going to get into the detail of what should be there, but people are saying this could be improved on. I don't want it justiciable, but let's enhance the vision of our society that's in Article 45, even if it's not enforced by the courts. The third point there, Jerry's point about emergency medical treatment from the South African Constitution is an interesting one. I mean, I think we're going to have difficulty finding a particular form of wording to put in here, but I would caution that, like, the Constitution does already protect the right to life and the right to health, and you don't want to be putting something in here that actually dilutes that right that's already there, by saying it's, and people have rightly pointed out that possibly emergency healthcare is too narrow. But look, we'll come up with a form of wording that kind of broadly reflects the consensus, and we leave it at that. The fourth point, by Katrina, you made 2 points, Katrina. The first was a very good point about the question 3, where you said that you didn't want any of the answers to those questions to dilute the level of protection that's already in the Constitution. And I think actually it reflects what I said earlier. We should probably put in some wording there underneath that question to say none of the above suggestions are intended to dilute anything that's already in the Constitution. Because otherwise we could find ourselves with all these unintended consequences that Michael McToole warned us about yesterday. And the second point that Katrina mentioned, in relation to emergency medical...
No, it was just cautioning against emergency.
Terms, that's right.
Yeah.
Sorry, Chairman.
And as Martina then amplified that comment as well.
Yeah, and finally, Chairman, just in relation to John's point there about the economy, I mean, that's something that could be reflected in the narrative of the report. I don't see it as being something to vote on, but there's no reason why we shouldn't put in a comment about that.
Well, I mean, the second question to some extent begins to address it, even not explicitly, because it talks about implications of possible reforms. I mean, implications, by definition, would involve cost, etc. And that we accept that these are not thought out. We haven't had time to think these out. But if people are concerned about that, that is a question to which they have recourse, if you like. So I think we're getting, I think there's some very useful suggestions have come up, which there's no showstoppers, I think, that have been suggested now. I mean, some changes, we can make some changes on foot of those comments. But let's see, is there anything else now that people want? Oh, sorry, Catherine. And Ivana, yeah.
Yeah, option 2 and option 3, I think I think option 1, it's very clear what the impact or the non-impact of that would be. I don't think it's as clear between option 2 and option 3. And the point, just to more or less expand what I'm saying on that is, yesterday we had a very good debate, and the like of the Jamie Sinnott case was brought up, and the point was made, was that the judge shouldn't be deciding about whether it's 10 or 20 hours of speech therapy. In actual fact, that was missing the point. The point was that it changed the way children with special needs were given options for education after those cases. It changed the way the department did something because the courts forced that change. Not for the ones that just appeared in the court, but for other children afterwards, in that there were special units for children with autism and things like that. And some of it's been rolled back. But the very fact that you could go to the court was a game changer in terms of how the department dealt with the issue subsequently. And I don't know, I'm not sure whether that is how that would occur with option 2, or what the option with option 2 and option 3 are, just using that example.
Okay, I think this issue about the different, what implications of each of these two options, we'll try and spell out a bit more so that at least people are clear about what it is we're voting on. Did I see another? Oh, Ivana, sorry, I beg your pardon.
Thanks very much. And just to agree with Catherine in terms of the impact of the Sinnott case, and I think there was a slight misleading about the result of that. Courts weren't allocating hours in that very direct, micromanaging way. Rather, the case did set out a precedent, which then the the other cases fell into line behind, and the state settled most of those cases, in fact, and offered hours to children because the culture was changing and had changed. And that's the point with a lot of the cases taken under the economic, social and cultural rights, is that they tend to change a culture. Just two very quick points, though, on the specific ballot paper, and well done again, because I think that, we are moving towards an agreement on it. I would agree that with changing social welfare to social security. And I think given that we're really only looking at the broad brush principles in terms of the rights we want to see specifically enumerated. So we're not specifying with housing, for example, whether, adequate level of housing or shelter. I think it's enough simply to say housing, social security, healthcare, rather than specifying exactly what we mean under each one. Let's just leave that detail for another forum. But I think what we're saying is we'd just like to see those rights protected in some form. And I would also ask that we might include a box of linguistic or cultural rights, since those aren't covered specifically beyond just the protection of the Irish language that we already have.
Okay. Leah, do you want to? Okay, Fiona, maybe. I think, and then we'll go back to Leah.
Fiona Wheeldon, just a quick comment on 4. I mean, is that going to be ranked order, or do we just tick yes, no for each? Right.
Sorry, no, it's yes, no. You can tick any one or more of them, or none, or all. Yeah.
Okay. Sorry.
Yeah. And just in relation to Catherine's point earlier there about the whole issue of the Jamie Synod case and so on. I mean, in that case, as far as I recall, the right of primary education was interpreted in his case to mean that he could get education up to 18 under the specific provision of the Constitution which deals with education. But the problem then is that his rights were not strong in relation to education throughout life. Correct me if I'm wrong on this, but that's something I suppose that in question 4 there, mentioning the rights of people with disabilities, I suppose we were kind of trying to make reference to that whole area. I mean, there is the whole area of educational rights for special needs and so on. And if some of you wanted to put that in, if we are having a blank box at the end of the page there, you could mention that. But that's an area where many people would say the rights are just not strong enough at all.
Yeah, I think, with your permission, the response that Leah has given and that I've given may now, I think, form the basis for another redrafting of this ballot paper. And hopefully we'll get it a bit closer to what you want to vote on. But I do think you're going to have to trust us on this, that we're going to do the best we can, taking account of the suggestions that have been made. And what you will next see in front of you is what you're going to be voting on. Is that agreed? Perfect. Okay, thank you very much.